Our goal is to provide you with some current HR topics on a monthly basis. So please look for next month's webinar entitled, "Do you want to be rich or do you want to be king?" relative to your leadership style. If you do have questions, first, if everybody could mute themselves, please. And if you do have any questions, please put them in the chat and I will address them at the end of our 20-minute webinar. Federal and many states have been very busy making your life difficult as you try to follow the bouncing ball of new regulations. Today, we're going to discuss the things you really need to check each year to ensure you remain risk-free. If you have never looked at your HR risk and have 2 or more employees, or if you are one of our HR partners, I suggest you take or have your clients take our no-charge HR MRI to find out if you or your clients are at risk.
Brian?
This will give you a baseline of things you need to correct or hire someone to correct. So the first thing that we're going to talk about are the processes and documents. The first step is really to ensure HR compliance and no fines or fees by the government. And for the first 2 that we're going to talk about, having these will protect you if you find yourself in DOL court. Okay, so number 1 is, and the most needed, is an employee handbook, your first protection. There are so many policies that are needed to comply with federal, state, and sometimes local government rules and laws, and new ones are passed each year. Your handbook really needs to be a living document, housing it online so that it is always retrievable and easy to update as law change is what I suggest. If you do it yourself, you should have an attorney review it. We happen to use an online tool managed by Jackson Lewis, a national labor firm, to ensure it's always legal for the state and federal laws. If you have a person who lives and works in another state, you need to understand that you need to follow that state's laws for that employee, not the laws of the state in which you're located. So it's kind of an interesting situation. Your handbook then should have addenda, depending on how many states, or an addendum if it's only 1, to cover the laws for that particular state. If you end up in DOL court, the first thing that they are going to ask is to see your employee handbook and a signed acknowledgement from the employee in question. So something that is really important as you start your HR compliance issues. The second is job descriptions. This is protection number 2, and also for those of you who are small, meaning around 3 to 5 employees, if you do a handbook and you do job descriptions, you'll be fairly well protected from employees who take you to DOL court. And if you don't know, DOL court is free for your employees. They do not have to pay if they take you to DOL court. But the judge, if you do end up there, always asks for these 2 documents. If you don't have them, they will rule on the side of the ex-employee 95% of the time. I have an interesting story. I had a client, and he got taken to DOL court for discrimination. He was a nationality that my client didn't even know he was, and they asked him to take out the garbage. Now, he was in shipping, and this was only the garbage from waste from the shipping area. They weren't asking him to go around and collect garbage throughout the company. And he said that that was discrimination. They were discriminating against him by having him take out the garbage. So off to DOL court, maybe this was regular court, and the first thing that the judge asked for was the job description. And in it, it said, take out the garbage from the shipping area. So the judge ruled on the side of the business owner, which is not always that great. It often happens. There's some essentials that you need to include in your job description. Some of them are fairly common that you would know: language skills, math skills, reasoning skills, those kind of things. But often people forget two that are very important, and they are physical demands, meaning do they have to be able to hear, walk, touch in order to do the job well? This is important because if you don't put it in your job description and you discriminate and by not hiring someone who can't do one of these things, then you could be looked at as being discriminatory according to the ADA. Also, you need to put the physical demands in the job description. The work environment. If they have to work outside year-round, it should also be in the description. If they're going to be in a noisy area, if it's very dry, if it's humid, whatever it is, if their job is to work proofing bread, then it's going to be very humid. So that's a couple of the things that should be in there. All right, the next thing relative to our issues is storing files. Interestingly, there are requirements, legal requirements, from 1 to 30 years based on the type of file. They can be paper or they can be an online file, but in either case, they must be locked up in a way. So that's going to be different from virtual or on-site, right? We do use software in 7-StarHR to do this, and that became very popular for us during the COVID time, because people couldn't get to the files that were back in the office, so they wanted them put online. To protect yourself, you really need to divide employee files into these 4 categories and designate who should have access to each of these files. Medical records, for example, is something you need to keep for 30 years. Confidential records may mean that the employee can see them, the supervisor can see them, but generally no one can see them besides those particular people. I-9s should not be included in employee files. They should be in one file for current and one file for all past employees. This ensures if you do get audited, the auditor does not have access to other types of employees' files. And you want the let's say you forgot to sign the files, it's a fine of $250 per person if they're not signed by the business owner. So you certainly don't want past employees in there, because if you don't want to have to pay for any fines for past employees. One file often missing in what's going on is applications. So if you are doing hiring, you must keep all applicant records and the job ads and any interview documents and all that. You need to keep that for 1 year before you can throw it out. For those, we use an applicant tracking system, but if you're just using plain files, paper files, then what you need to do is store those records and not have them get lost somewhere. This helps protect you against a claim of discrimination. You can take a look, well, this is what the job was, these are what we required, these were what our interview questions were, those kind of things, so that you're protected. Posters. If you aren't posting posters and you have one employee, you need to start doing that. Anyone that happens to come into your office to do any kind of audits is going to look at whether or not you have federal, state, and local posters. You can either buy an online all-in-one poster, that's what some people do, or there are places you can go to print them out on the web, and that way you don't have to pay for them at all. Either way, there are some which must be posted, like the notice from your state that says your employees are covered because you're paying unemployment insurance. That should be posted on the wall. And it should state in your handbook where these posters are posted. You need to update these on an annual basis. That's really important because, again, as I said, the laws continue to change. Okay, OSHA. Most small business owners think they're not liable to OSHA, especially if they're not in manufacturing, and this is not true. Here's what some of the OSHA requirements might look like. An employee can become disgruntled and report any company to OSHA, and they're obligated, based on that complaint, to come in and do an OSHA audit. You need to do signposting showing exit locations. How do you get out of this place? Just think, even if you only have a couple employees and you have a visitor and a fire breaks out, you need to have that. You need to have room capacities if you have large meetings. And if you have a little kitchen area, there needs to be a post on the door saying, we're doing a microwave here, because there are many people that have internal medical equipment that can be harmed by microwaves. If you have 20 or more employees, you must keep track of the accidents and submit to OSHA forms saying what those accidents were, and you need to post the summary within your organization. Some of these other things, first aid kits, having fire extinguishers, it's not on the list. Training your people, maybe doing fire drills if you have, a few people that don't know where to go and what they should do. All of that is is really important to your business and can cause you, OSHA fines are really horrendous. So you want to make sure that you're not liable for any of those. Okay, so that takes care of our processes and procedures. I want to go on to some other things that have some pitfalls that can cause fines and fees, and hiring is definitely one. If your application has Social Security numbers on it, and a lot of them still do, that was something that was popular at one time, to put our Social Security numbers all over the place. You need to have a theft protection process for those Social Security numbers. That's something that's a pain in the neck. So much easier to take the Social Security number requirement off your application. When you hire someone, then you can ask for the Social Security number. Or if you are going to do background checks, you can ask for the Social Security number then. You don't need to have it on your general application. Okay, EEO, Equal Employment Opportunity. Most of us feel we're not discriminatory, but EEO requires those with 15 employees not to discriminate in some very specific ways. And I suggest, really, this is a good practice. We all be careful using some words in ads, like, I'm looking for somebody that's energetic, or I'm looking for, or you say him or her, he or she, somewhere in it. Both of those could be considered discriminatory. The first, on age, might be thought that those that are older are not as energetic. So, you know, that's something that you might not think of. You really have to be careful and watch for what that is. And then, you know, in this day and age, discrimination based on gender is really something that you want to protect yourself from. And just using he's and she's, there are a lot more genders now than he's and she's, right? So you need to not do that. The Equal Pay Act is one that applies to all employers, even with one employee. So if you have two employees in the same job, you need to look at their compensation to make sure that you can justify why a man or woman is making more than someone of the opposite sex. Either way, you cannot discriminate. So do a little audit of what your pay is for all different job titles. And the other thing you can do here is, if you have somebody that's brand new, obviously you're not going to pay them because their knowledge isn't as much. But if you can set levels within a job, so I have a level 1, 2, 3 of customer service, then you can justify paying them a different amount with the same job title. Lastly, interns. Another area you can get in trouble with is bringing in interns. You can get in trouble if you're not paying them, unless they are coming into your facility through a school program where they get credits for working for you. You must pay them your state's minimum wage. So that's something that I find that people mess up and think, oh, I'm going to get an intern to come in and do all this work for me. And that's fine. And maybe minimum wage, whatever it is in your state, is much less than what they're paying the regular employees. So that might be a good way to go. And having interns come in helps you in the hiring process, right? If you can have a farm team. But be careful. Make sure that you're paying them appropriately. Okay, speaking of paying or misclassification of employees is another topic here for us. So there are pay laws, federal pay laws. The first one that I'm going to talk about is exempt versus non-exempt, or salaried. Some people call it the same thing. Exempt from overtime is what exempt means. And I've had some clients who decided they were going to negotiate with people to pay them, hey, I'll give you 45 hours, but I want to pay you straight pay for that other 5 hours. Is that okay? And when you're going to hire someone, that puts a burden on them. And of course, they might say yes, but that is totally illegal. You must pay time and a half for hours worked over 40 per week. You may not offer comp time unless it's within the pay week. So what that means is if they work 16 hours for 3 days within a week, no overtime is required, right? If you work 60 hours one week and 20 the next, you must pay them 20 hours at time and a half. If they if they worked 3 hours over, maybe 11 hours one day, and the next day you said, just come in 3 hours later, perfect. You do not have to, that you can comp them, but not in a different week. Now, in New York, interestingly, and I don't know about some of your other states, we do have something called the Wage Theft Act, and it requires us to fill out a form when you hire someone, and it tells them specifically what they will be paid for overtime, and that must be turned into the payroll company. Also, if you give someone a raise, they must be given that wage theft form again. So take a look and make sure you know if you have a similar law in your state. Okay, so salaried, which is often talked about. I think I'm going to make this position salaried. And if you do want to change someone from to salaried, from hourly to salaried, and think that by changing them, that makes them exempt from overtime, that isn't necessarily true. You can see in this list the amount of pay, and this is a federal thing, the amount of pay, the type of position, their decision-making authority, their policy-making authority, and usually it's management of at least 2 employees, or possibly you cannot have them manage employees if they're a project manager where they manage a huge project, but not necessarily employees. That might compensate, make you in compliance with that. Okay, the next thing that often happens is, oh, employees are such a pain. I think I'm just going to make everybody 1099s or independent contractors. And that's an area where you might find yourself paying the government back Social Security and all of the your portion of the IRS taxes if you don't do the right thing. The general rule is that an individual cannot be an independent contractor if you have the right to control or direct what they're going to do, how they're going to do it, and when it will be done. It's that simple. In the audits I've seen on this, auditors come in, and what they do is ask for a list of the checks you've written, all of them. If you're writing a check to an individual and they're not on your payroll roster and you're paying them more than $600 per year, they are going to consider them an employee. And that's going to put you in a bad way. To protect yourself, it's not that you can't have 1099s, but to protect yourself, you should have written agreements between you, not in them, but their company. So they really should have their own company if they are going to be independent contractors. Also, you really should not provide them with any tools. They are independent, so they should be providing their own tools. So you can't say, well, I'm going to give you a laptop to use. No, that's not acceptable. Now you're starting to get into the employee area. Okay, so unfortunately, even benefits and payroll can cause you problems. So for payroll, you want to make sure you are following state laws on how often employees must be paid. Now, if you're paying all employees once a week, no matter what, then you're golden. But if you're paying people once a month, twice a month, or every other week, you should be checking the what your state law says. Because if you're not paying them appropriately, it can cause you fines. One of the things having a payroll company can do is ensure no mistakes are made in the timing of federal taxes, which are withheld. If not done properly, can cause you a big fine. I ended up with a client, and the first thing I said, he was using the IRS money to float his business, and I said, well, I guess my first job is to help keep you out of jail because you can't do that, right? And if you have a bookkeeper or an accountant in the firm and they make a mistake and forget to pay, you're liable, and it will cause you big fines. Your payroll company will also make all the legal documents for onboarding new employees are signed so that you don't get fined in an audit. That's important. You need not only you need the I-9s, those kind of things. If you're not using a payroll company, and it's more than just you, I really suggest you do so. You don't have to go with the big guys, ADP or Paychex. There are some lovely, good, smaller payroll companies local to where you are, and they will protect you in this particular case. So there's some other benefits here that can cause you problems. Sales commission plan. If you have sales reps, you need a written commission plan. If you don't put it in writing and have the sales rep sign the plan, in any dispute the DOL is involved in, DOL will rule on the side of what the sales rep says the plan is. They believe it's the employer's responsibility to have a written plan. In some states, like New York, it is the law to have a written plan. And lastly, if you provide your employees with a 401k, it's imperative to ensure the submission of all required documents on an annual basis. And that's called a Form 5500. And if you do have one, it's really important to understand whose responsibility is to complete them. Someone may say they're completing them, your 401k provider, but you are totally liable, just like taxes. So you want to make sure that they are doing that. If you or your 401k provider fail to file to meet the filing requirements on a 5500, the IRS and DOL may impose penalties. These can be as much as $250,000 I've seen for a company with 4 to 5 people in their plan, even if you are the biggest provider. Okay, so we're going to ask if there are any questions. Let's see here. I don't see any in the chat at this point. Are there questions that any of you might have? Okay, Parity.
Yeah, I just had a couple questions. One, on the OSHA, you mentioned that we need to post a summary of any injuries, like from the following year, I'm guessing. Where is that to be posted? Could that be, like my company, we're about 60 or 60 plus employees. We do have a social media platform that all of our employees are, it's called Workplace. It's kind of like Facebook, but there's a knowledge library in there, and we keep a lot of, like, our handbook digitally is there for the employees to look at. Is that where we would post something like that? Or do we just...
if you're doing it online, you must have a place to post it, and wherever you post all your other posting requirements for the government, that would be the place to post it.
Okay, and then another question on just that last, on the 401ks. You know what month those are supposed to be filed annually, the 5500 form?
I think it's the first part of the year. I don't remember in specific what the time is, but I think it's the first part of the year for the previous year.
Okay,
from Roger. So personality assessments, are these considered high risk, like employee applications or interview notes? So the results of those should be kept for a year, just like your applications and the job description. Any assessments that you give should be kept at least for a year. Do independent contractors have to hold an LLC, or can they operate as doing business as? So I am going to leave that to your accountant. For us, we like to have an LLC. The doing business as is usually when you're an LLC. So maybe you had your company, your LLC might be SCCEC, Silka. Maybe that would be your company, LLC, but you're doing business as the greatest coach on earth. You know, that would be your DBA, is the DBA, the greatest coach on earth. And doing a DBA just allows you to bill somebody and deposit checks into the bank. They want to have the DBA if you're having checks that are coming in with a different name from the corporation that you opened at the bank. Any other questions? Okay. So I highly recommend you do the HRMRI. We have different sizes based on the number of employees you have, because different risks. To get your free one, you can email Kimberly at SevenStarHR.com. Make sure that you include the number of employees you have. Again, if you are one of our partners, you can, or even if you aren't, you can do this with your clients. So thank you all for attending. Don't forget, we're doing these on a monthly basis. Looking forward to seeing you again soon. Take care. Bye.